Hello, everyone. Welcome to Joe the Lawyer. Today, we're going to look at a couple of news articles that show us how the coronavirus is impacting the practice of law. First, we're going to look at this case that ended in a mistrial because one of the attorneys was so sick and coughing, the judge decided they couldn't even go on. Then we're going to look at an article about two attorneys who got into I don't know what to call it, a playground fight over depositions, and they had to be bench slapped by a judge. Hello, everyone. I'm Joe Pometto, Joe the Lawyer, practicing Pittsburgh attorney. I do criminal defense, family law, personal injury, a little bit of everything. Here at this channel, I talk about new laws. We break down the law. We look at news articles, and I give helpful legal information. If you like my content, please like, subscribe, comment, and share. It's a free way to support this show. Looking for subscriptions right now, trying to get to 1,000. So if you watch a show, you're not subscribed, go ahead and subscribe. It's totally free. Also, if you sign up for my email list below, you will get a free PDF on what to do when stopped by the police. Now let's look at this first article. New York City sex abuse case ends in mistrial after defense lawyer shows up with coronavirus symptoms. This is March 16th, 2020. Eric Braverman in state Supreme Court. Here's the guy right there. He's going to get sick. Okay. A Manhattan judge declared a mistrial Monday in the case of a doctor accused of sexual abuse after his defense attorney arrived to court with coronavirus-like symptoms. Justice Ruth Pickholtz put a halt to the trial of Eric Braverman after lawyer Donald Vogelman. Oh, that's okay. That's Eric Braverman. This is the guy on trial. That's not the lawyer. Donald Vogelman showed up at Manhattan Supreme Court experiencing fatigue, coughing fits, and a high fever, all symptoms of the fast-spreading COVID-19 virus. Instead of appearing in the courtroom, Vogelman attempted to examine a defense witness via speakerphone from the 16th floor conference room, but he kept having audio issues and struggled to speak loud enough to hear. So apparently this attorney is in a different room while the judge and I'm assuming the jury and the other lawyers and the parties in the case are in the courtroom. This guy's trying to cross-examine from a speaker in the conference room. There's the lawyer, Donald Vogelman. Okay, do your tie there, buddy. Do your tie up. Jurors, this case is over, Pickholtz said. I have to declare a mistrial. We need a fair trial. We need a lawyer who can represent his client. We need everyone to stay healthy. Your service is over. Stay healthy. Stay in touch. Braverman, 60, faces one count of forcible touching and third-degree sexual abuse on allegations he molested a female patient inside his practice at East 23rd Street and Park Avenue in July of 2017. Park prosecutors said he persuaded a young woman he met at a networking event to come to his medical practice so he could cure her of eczema. Come on, man. Then sexually molested her under the guise of a holistic massage. His trial began last Thursday. Boy, this is a sad case. There he is. That's the defendant. As Monday's proceedings went on and Vogelman's symptoms appeared to worsen, Braverman argued in vain to represent himself for the remainder of his case. There's a saying that a person who represents himself as a fool for a lawyer. Even lawyers who are accused hire lawyers to represent them, the judge advised Braverman. It will be a 3-month delay until I get another trial, Braverman said. I can't come up with another $30,000 or $100,000. Vogelman also tried to dissuade his client from representing himself before being sent home by the judge. You might be a brilliant doctor, but you don't know the rules of evidence, Vogelman told Braverman. I just can't do it. I have an obligation as an officer of the court, and I should really go home. You should leave the building now, Pickholtz responded. The judge adjourned the case to June 22nd. A spokeswoman for the Manhattan DA said it will move forward with the case. We intend to retry this case and secure justice for this survivor. Office of Court Admin Lucian Chaufin said the conference room Vogelman called from will temporarily be closed and deep cleaned. Boy, I hope it will. Attorneys get ill or die in the middle of a trial. I'm sure that while this situation is unprecedented, an attorney becoming incapacitated has precedent. Vogelman isn't the only person not feeling well at the trial. A juror who claimed to be immunocompromised called in sick Monday, citing fears about the coronavirus outbreak. On Friday, 2 jurors called in sick and were replaced with alternatives. It's not clear if they had been diagnosed with COVID-19. So I had originally pulled up a different article to talk about this. One of the other articles I read said this attorney is in the conference room trying to cross-examine this witness who's in another courtroom, and he's coughing hysterically over and over into the conference room speaker. Okay, and he's like asking questions. So, do you recall where you were on that date? Okay, coughing repeatedly all over the speaker. And the judge apparently was mortified by it and was worried that he was going to, contaminate the entire room and or pass it on to other people in the building, even though they had quarantined him off. So I just thought that this was a funny story. The judge tried to accommodate for this trial, but obviously this attorney was just too sick. There's the doctor there, and let's scroll down. There's the attorney who was sick and was coughing all over the microphone or the conference speaker. So you can see here, and this is New York City, which is very hard hit from the coronavirus. It's really tearing up courts everywhere. What I had read was New York shut down all trials and jury trials except for ones that were already scheduled. I think that was a bad move. They should have just canceled them all. Look what happened. They're trying to hold this trial. Well, this was March 16th. Still, initially they were trying to hold these scheduled, they might have shut them down now. They were trying to hold these scheduled trials, and they got this guy with the coronavirus coughing all over the place. Let's look at this other article here, okay? I found this on Above the Law. It's from March 27th. Judge bench slaps attorneys for thinking their case is so important in the middle of a damn pandemic. Hang on a second. Let me get a drink here. Perspective. That's really the key to litigating or homeschooling or shopping or everything during a global health crisis. That's the point that Wachtell partner William Savitt was making when he took issue with lawyers getting their panties in a bunch over non-essential cases. And it looks like Magistrate Judge Jonathan Goodman totally agrees. Let me stop real quick. The courts are closing everything except essential business. So non-essential business you're not supposed to really be doing. The case is CW versus NCL, okay, so out of the Southern District of Florida, and it started as a scheduling snafu over a corporate representative deposition, which really, even absent COVID-19, shouldn't be that big of a deal. But the plaintiff unilaterally scheduled the deposition, and defendants filed an emergency motion for a protective order. And, well, Judge Goodman had just about enough of this foolishness. So what's going on here is these two attorneys are in litigation, and the plaintiff wants to take the deposition, which means interview under oath and record. So at a deposition, you record the testimony, you interview the person under oath, a corporate representative, someone from the company that they are suing. All right, again, this isn't a huge deal. Generally, these can be scheduled at any time. But this plaintiff apparently was trying to push it, and he may be doing that to try to put pressure on the defendant to settle. The judge got upset, and here's what he says. He says, presumably, the parties will reschedule the hearing if they still can't, on their own, resolve a routine deposition scheduling snafu. Nevertheless, I feel compelled to offer some observations in the let's keep things in perspective department. The entire world is in the midst of a pandemic. Thousands of people worldwide have contracted the coronavirus, and there have been hundreds of virus-caused deaths in the United States. Millions of Americans have been ordered to remain in their homes. Millions more have lost their jobs. The stock market has taken a brutal beating in the last 2 to 3 weeks. Many people are scared. Others are panicked. Everyone is unsure about the future. Cruises are canceled and major airlines have severely curtailed their flights. We are living in an unprecedented situation. Nevertheless, the lawyers in this case, this just shows you how petty and minors attorneys can be, how childish they can be. The judge says, nevertheless, the lawyers in this case have been exchanging snippy emails over the past 2 weeks over the scheduling of a corporate representative deposition. Moreover, defense counsel certified that this routine discovery dust-up is so important that it merits emergency status. No, it doesn't. That's the judge that said that. He said, no, it doesn't. And the order goes on, slamming the plaintiff for thinking the defendant, a cruise line no less, throw a little bit more irony into this, would be able to comply with the deposition request right now. Local Rule 7.1D requires a movant seeking emergency relief to certify a true emergency exists, because meaningful relief could not be provided on a critical, non-routine issue within 7 days. A spat over the specific day of a corporate representative deposition is hardly critical. It is, in fact, routine. Moving past the incorrect and frankly reckless designation of this dispute as an emergency, the judge is shocked that counsel could not on their own resolve the issue given the health and economic crisis we are in. Not postponing the deposition scheduled for next week is patently unreasonable. If all the issues we are currently facing were to be organized, I love this line here. This is Joe. Okay. If all the issues, this is the judge, back to the judge, we are currently facing were to be organized on a ladder of importance, this deposition scheduling dispute would not even reach the bottom rung of a 10-rung ladder. It is painfully obvious that counsel for both sides failed to keep their comparatively unimportant dispute in perspective. He goes on here, and he finishes. So the deposition will not be taken next week. Life will go on, but the undersigned, who's the judge, will be requiring counsel for both sides to appear for a hearing at some point, even if they work out the rescheduled date for the corporate deposition. That hearing will require the attorneys to explain their behavior in context of the far more important issues this court and the world is facing. The journalist goes on to say, I don't even have much to add. Judge Goodman handles the matter with aplomb. You can only imagine the finger pointing that will go on when the attorneys are dragged in front of the judge to explain themselves. Boy, would I like to be a fly or just a silent observer in that courtroom. FYI, anyone can observe court. During a motion such as that, it's open to the public. I got a kick out of that. So, judges are laying down the law here. The courts are trying to roll with the punches with the coronavirus. You got these two childish attorneys fighting over nonsense. What other stories will the coronavirus bring in the legal world? Tune into Joe the Lawyer to get more of the action in the coming days and weeks. Thank you very much for tuning in. I hope you got a kick out of this, and I hope we learned something at the same time. If you like my content, please subscribe, like, comment, and share. I'm looking for subscriptions right now. I'd love to get to 1,000. Help me out. It's a free way to support the show. Here at Joe the Lawyer, we cover the law in depth. We cover legal news, and we cover other useful legal tips. Until I see you next time, Joe the Lawyer out.